Good evening, friends. Today we are meeting for the lecture of Public International Law. Friends, we have discussed what is international law, what are the definitions given by the different jurists, how it developed, how it was when in ancient times, in which kind it is right now in 20th century. That all we have discussed in last lecture. Today, we are going to discuss about the important topic of public international law, which is settlement of international disputes between the states. So, friends, if two states are working differently in their own manner, there will be no need of any dispute. No dispute will arise in case of separate situation. But if two states are in kind of situation where one need the assistance of other or to start functioning for its own government, then there will be the collision of functions of two different states. Friends, this settlement of international disputes between states, it says that in case of any dispute which is arise within two or more states, then the settlement is also available under international law. To start with the topic, first we should know the meaning of dispute. Dispute means any disagreement on a point of law or any kind of question within two states. That is the meaning of dispute. Two states are not agree for one point, for one subject, for one topic at the same situation. It is called dispute. One is claiming something, other state is not providing, not satisfying that claim. It is called dispute. Now, as per international law, dispute has two kinds. Let's go through the slide number 1, which says that dispute includes two kinds of dispute. One is legal dispute, second one is political dispute. This legal dispute and political dispute both are considered as dispute in international law. International law is concerned with only legal disputes. If you see through the slide number 1 says Article 36 para 2 says that International Court of Justice can deal only with the legal dispute. Then if dispute is concerned with legal dispute only when we are talking about international law, how can we define the term legal dispute? For that, the famous international case is there, which is of Nicaragua versus Honduras. Let's go through the fact of the cases. In this present case of Nicaragua versus Honduras, the dispute was regarding maritime boundaries. In the Caribbean Sea, there were 4 different islands scatteredly situated between Honduras and Nicaragua. In this case, if the states or the islands which are scatteredly situated, the question was about deciding the boundary, maritime boundary was the question in issue. Then the second question which was involved under this case was about the sovereignty of these 4 states. Nicaragua was claiming that all the 4 islands were belonging to the state of Nicaragua, so it will be the part of the map or boundary of Nicaragua. Honduras contemplated that though they are very near from the boundary of Nicaragua, but they are not the part of the territory of Nicaragua. All these four different islands are connected with Honduras. Now, the question was relating to the sovereignty. It can be considered as political issue or a legal issue. Sovereignty also includes the territory and the boundary of the states. So they went to the International Court of Justice to solve this dispute. While dealing with this case, International Court of Justice held for the first time that International Court has relation or International Court is concerned with the legal dispute only. As this issue includes maritime boundary and sovereignty point, it is considered as legal dispute. So, International Court of Justice has the jurisdiction to solve the present case. And my friends, by its judgment, International Court of Justice said or held that the Honduras, state of Honduras, which is situated nearby the Caribbean Sea, it is having sovereignty over all those four islands. So, Nicaragua was not allowed to attach all these four states or four different islands with its territory. So friends, for the first time in this Nicaragua versus Honduras case, International Court of Justice held that in public international law is concerned with the legal dispute only. Then what is the meaning of political dispute, or how can we define political dispute? If one would like to describe the meaning of political dispute, jurist says those disputes which are not legal disputes, they are called political dispute. By this definition, it is not easy to understand the meaning of political dispute. Let me clarify it easily. As per political dispute, if states are under the fear that if we send or we refer any judiciary to solve our question, judiciary will give decision in opposition to us, then they will consider this issue as political dispute and they will solve this political dispute as per their local mechanism. So legal dispute and political dispute, now it is clear friends? If it is clear, then now we will go to the legal provisions for this dispute. As per the Statute of International Court of Justice, Article 36, Para 2 and Para 6 states that International Court of Justice will held only legal dispute as its jurisdiction. Now, if the question itself is regarding whether the dispute is legal dispute or it is political dispute, then the jurisdiction is with International Court of Justice as per Article 36, Para 6 of Statute of International Court of Justice. This Article 36, Para 6 says that in case of dispute which involves the kind of the dispute, the decision of the International Court of Justice will be the final decision. So if any dispute is put before the International Court of Justice and court says that this dispute is legal dispute, then it will be settled down as per the methods prescribed by international law. If the Court of Justice says that this dispute is not a legal dispute but is a political dispute, then that dispute will be solved by the local machineries. So these are the legal provisions regarding dispute. What is the meaning of political dispute? What is the meaning of legal dispute? Now let's go through the second slide, which shows that which are the modes for the settlement of dispute. As per this slide or this chart states that means available for settlement of disputes. How many means are available? Mainly there are two methods or two means available for settlement of international disputes. As I have disclosed, amicable means and coercive means. Friends, in layman language or in our day-to-day language, these two words denotes two different words. Amicable means includes the peaceful settlement, and coercive means includes the forceful methods. As per the amicable means, there are two main sources, two main methods available for settlement of dispute. The first is extrajudicial peaceful methods and second one is judicial peaceful methods. The whole chart disclose very easily the methods available for settlement of dispute. Today we are going to discuss about the peaceful settlement of dispute or amicable means available for settlement of international disputes. The first method available as per the international law is extrajudicial peaceful methods and judicial peaceful methods. Now, if the peaceful method, if state or a member state does not want to follow, then what will be the consequences? See, to solve any international dispute through coercive means, which is very easily available, and the solution is always successful because the one who is having power in his hand will follow their wishes in the solution. But if you go through the amicable means, then the Charter of the United Nations is with you. Various different declarations, various different conventions are available for this amicable settlement of dispute, which is known as peaceful settlement of dispute. Friends, these amicable means are already defined or already provided under the Statute of United Nations of Organization. Article 2 of the United Nations Organization says that United Nations Organization available for peaceful settlement of dispute. મિત્રો, યુનાઇટેડ નેશન્સ ઓફ ઓર્ગેનાઇઝેશનનું જે ચાર્ટર છે એની અંદર આર્ટિકલ 2માં એવું લખેલું છે કે જેટલા પણ સભ્ય રાજ્યો all member states are bound by the charter to solve the dispute through amicable means. જેટલા પણ સભ્ય રાજ્યો છે તે તમામ રાજ્યો પોતાના વચ્ચેના પ્રશ્નો એ આ શાંતિપૂર્વક પતાવવાના પ્રયત્નો કરશે. સાથે સાથે આ ચાર્ટર એ પણ પ્રોવિઝન આપે છે કે these peaceful methods are as follows. So the statute itself enumerates the various methods available for peaceful settlement. It not only provides for the method recommended by the UNO, which is the amicable method, peaceful method or શાંતિપૂર્વકની પતાવટની પદ્ધતિ. આ સોર્સ દ્વારા માત્ર એની પદ્ધતિ પણ મળે છે, સાથે સાથે the modes available which are by negotiation, by good offices, by conciliation, by mediation, by arbitration, or lastly, or any other method of the choice of the state. See friends, the statute not only provides the various methods available for peaceful settlement, but it provides other area for settlement of dispute from the phrase or as per the choice of the disputant states. So if states are of the opinion that we should opt other method than prescribed by the charter, they are welcomed to solve the dispute by this other or choice based method. So this is the preface of the methods available under the United Nations of Organization. Now if you look into the slide, it says that amicable means include extrajudicial peaceful means and judicial peaceful means. This extrajudicial peaceful means includes negotiation, good offices and mediation, conciliation, inquiry, and by the United Nations itself. So this extrajudicial peaceful means includes 5 main methods to solve the dispute. When any dispute is referred other than the judiciary, it is called extrajudicial methods. If states are not ready or not agree to send